So, the reason that I'm going through this literature for everybody is it doesn't just apply to officers of the law, sheriff's department, state troopers, police department, okay? This also applies to those nasty, rancid sons of bitches that work for CPS, okay? When they're unlawfully holding you against your will, trying to keep you a prisoner in your house, telling you that you need to bring forward your offspring so they can inspect them, okay? They're doing all this without a warrant, without probable cause. They have no reasonable, articulable suspicion for their conduct, and they have no reasonable, articulable fact to support their reasonable, articulable suspicion. All they have is mere hearsay, and you shut those rat bastards down and let them know, hey, you're violating my unalienable rights, okay? You're violating my right to life, liberty, the pursuit of happiness, to be peaceful and sensible within my community, to have my right to be secure in my persons, houses, papers, and effects, and you need to be about your way, okay? I charge $2,500 a minute for bullshit meetings, and I'm just putting you on notice now. I'm starting the clock. You're free to go at any time. They should probably Mirandize you too, because the criminal activity that you're involved in. So let me go ahead and do that. You have the right to remain silent. Anything you say can and will be used against you. You have a right to counsel, not an attorney. But you may hire an attorney, and I'll shut him down with Trinsley versus fucking Pagliaro, because he don't know what the fuck he's talking about, because he has no first-hand knowledge, and he can get the fuck out of my court. All right? You have the right to terminate this investigation anytime you see fit. I am not holding you against your will, and you are free to leave. And I would advise you that you probably do so. However, if you still wish to engage with me at this point, I need your full name under the Real ID Act, also under Title VI CFR, what is it, like 361 or 365, go look it up. It tells you about the full legal name. And I need your address as well, because this is going to turn into a suit, okay? And I'm just duly informing you of where we're headed if you persist on believing that some benign corporation gives you the authority to accost me against my will, detain me, and ask me all these questions without reasonable articulable facts and reasonable articulable suspicion that I'm engaged in felony activity, that I have caused harm, damage, and loss to somebody without having two witnesses to verify the same, swearing under the pains and penalties of perjury with an affidavit in tote, securing a warrant to be able to do what you're doing. All right, and that's why I'm doing what I'm doing now, is just to kind of show you that this applies to everything. False arrest and false imprisonment is the conduct of anybody who is trying to stop you from going from point A to point B, and you have reasonable fear that harm may come to you. Now, it's not too hard to articulate to a jury of 12 nowadays that you are reasonably in fear for your life with a gun-toting moron with an IQ of 70 who continually shoot unarmed 12-year-old children because they feared for their life. You know, it's not unreasonable to know that you can articulate this to a jury of 12 and they go, yeah, that ain't no fucking shit. It's in the paper every fucking day, folks. All right? And that's the other reason that I explained to you about status. So many people talk about status correction, but nobody's really telling you how to do it. I've been instructing you guys on this for the last 2-3 days now. And then this directly correlates and ties into false arrest and false imprisonment. And if you stand on these sound doctrines and principles, I'm telling you right now, you stand on these sound doctrines and principles, you are good to go. So let's get started again here. Again, this just doesn't apply to what people perceive to be law enforcement or cops or whatever. It applies to CPS agents. It applies to, anybody that's trying to hold you against your will, moving from point A to point B at your leisure. It's a breach upon your liberty. It's a common law trespass, which leads to a tort, which is causing harm by way of false arrest, false imprisonment, assault, battery, and these are the very grounds for you bringing a claim. And I'm telling you right now, you do this one time in a community, they will leave you the fuck alone. Because the last thing they want is to be losing agents and agency, which is exactly what happens when you bring a claim against their bond, when you sue them successfully, when you notify them of their breach of the peace, that they're causing you harm, damage, and loss under false pretenses, which is oftentimes what they're doing. They're saying, statutorily, you're obligated. Well, first of all, I don't answer the fucking legislator. The legislator answers to me, period, all right? And you have to understand the basic fundamentals of why the Constitution was even put into place. It was put into place to restrict them and tell them what the guidelines and the boundaries for which the parameter and the scope of their work must be within, okay? And everything other than that is reserved to the people of the state. Article 1, Section 9. Article 1, Section 10. Okay, real simple shit. Real simple stuff. And I'm telling you right now, every agent and agency is working for a corporation with a DUNS number, insurance. They're involved in commercial activity after the Reorganization Act of 1871 and the executive orders and the soft martial law that we're all involved in. It is very, very important to establish your status, okay? I've got some more acquired knowledge as of recently. I realize with all the studying that I'm doing that under the executive order in 1933 for all persons to bring in their gold, those were only persons that were subject to Washington, D.C., the district of fucking criminals. The vast majority of American people did not have to turn in their gold, thus, because of their ignorance, willfully volunteered to turn in their gold and silver. Now that there is an atrocity, and that atrocity I blame on the American people not being steadfast in gaining the knowledge to protect their life, liberty, pursuit of happiness, and be secure in their person, houses, papers, and effects, and property. Okay, it's a travesty that we've come this far, and that it got so far because people didn't realize what was really going on. I am not the brainchild of all this work. I don't have, I'm not a genius or anything like that. I just read a lot, and you can, too, also acquire this knowledge and make sure that your friends, your family, most importantly yourself, are protected in your community. The specific authority for arrest is grounds in the ancient settled maximum of law, which no statute can abrogate without violating due process law provisions of the Constitution. Thus, a warrant must be obtained for a misdemeanor that is not a breach of the peace. The Supreme Court of Minnesota has stated on several occasions that even in the case of a felony, an arrest and search should not be made without a warrant unless there is compelling necessity to do so. Basically, if somebody's got a gun, they're screaming at the top of their lungs, I'm going to go shoot that bitch. Yeah, they've got a duty to intervene for the public safety, okay? State versus Mastrin, 285, Minnesota, 51-57. This case was affirmed in 1969. The Supreme Court of Rhode Island is, in declaring the requirements of the common law for an arrest, stated that the law permitted an officer to arrest without a warrant on reasonable suspicion based on his knowledge that a felony had been committed, okay? In all other cases, and what that's saying is that he has reasonable articulable suspicion supported by a reasonable articulable fact to believe that a felony has been committed, which means that he's got two or more witnesses swearing to affidavits saying, yeah, this is what happened, and he's got an injured party going, I'm the one that's aggrieved. I'm the one that has been violated. Then and only then does he have the power to arrest without a fucking warrant. Prior to that, he has to go get a warrant, okay? In all other cases except the case of a misdemeanor amounting to a breach of the peace committed in the presence of an officer, which again means that he has to physically fucking see it, an officer had no authority at the common law to arrest without a warrant. And again, if the agent and agency, the officer, is seeing a breach of the peace, he has to say, hey, I need you to stop with this conduct. It's menacing, and I'm going to give you an opportunity to stop. If you persist on after he's saying, hey, you're breaching the peace here, if you don't stop, your conduct is unbecoming and I'm going to have to arrest you. They have to give you an opportunity to stop the behavior that you're exhibiting that may or may not be a breach of the peace. To arrest without a warrant. Authorities cited Kaminsky versus Durand, 64 R period I 387 12 ATL period 2D 652 654 1940. In American Jurisprudence 2D Volume 5 under the subject of arrest, Section 26 and 28, pages 716, 718, it states, at common law, a peace officer cannot arrest without warrant for a misdemeanor, although committed in his presence, unless a breach of the peace is involved. Now, they're talking about a peace officer. Ladies and gentlemen, we don't have peace officers anymore. We have policy enforcers, okay? And those policy enforcers are enforcing legislation, which I perceive to be taxation without representation, and it's rather benign because they're saying that somehow you're subject to the whim of Congress, which can make no law. Okay, Congress can't make any law that pertain to the people. They only make law that pertain to their subjects. Okay, and their subjects are officers that fill branches of the government and anybody who volunteers to be a U.S. citizen. All right, and the legislators can't make any law either. The only policies that they can make are that which apply to their agents and agency. Remember, those who create the law are the ones that are bound by it, and those who are participating in it are bound by it. So essentially, if you don't work for Walmart, Walmart's policies don't apply to you. They don't affect you in any way, shape, or form, okay? And if Walmart tries to enforce their policies upon you as though you're an employee, you have grounds for a suit. Because you're not gainfully employed, you didn't enter into a compact with them, you have no obligation to abide by their policies, right? Okay, let's move on. At common law, the right to arrest for a misdemeanor committed in the presence of the officer is limited to those offenses which amount to breach of the peace. The basis for the rule is that the arrest without a warrant is permitted in cases less than a felony, not for the apprehension of the offender, but only for the immediate preservation of the public peace. And accordingly, when the public peace is not menaced, a warrant is necessary. Authorities cited, see also Section 22. In Corpus Juris Secundum, Volume 6A, under the subject of arrest and under the heading of arrest or detention without warrant, subsection 10, page 17, it is written, at the common law, however, it has always been the rule that, except in cases where the public security has demanded it, arrest without a warrant is deemed to be unlawful. Due process of law, which declares that no citizen shall be deprived of any of his rights of life, liberty, or property unless by law of the land. Remember, law of the land is not policy. It's the law of the land. It's also supported by the Magna Carta, the Federalist Papers, the Bill of Rights, the Declaration of Independence, okay? Or the judgment of and every all 50 states constitution, or the judgment of his peers, Minnesota Constitution, Article 1, Section 2 and 7, also found in every constitution throughout the 50 states and the Union states, okay, is the controlling factor in the matter of the arrest made by the defendant. And arrest is a deprivation of one's liberty, and the due process that must be followed in an arrest is that process which existed at the common law. To prevent the exercise of arbitrary power at the discretion of government, it was deemed wise to secure principles already settled in common law upon this vital point of civil liability in written constitutions, Cooley Constitutional Limitations 364 and notes. Where Chicago policemen arrested a man for vagrancy, the officer was found guilty by a jury of false imprisonment. The Supreme Court of Illinois has upheld the conviction of the policeman and declared the rule of law regarding arrest without warrants. Blackstone says, the constable hath great original and inherent authority with regard to arrest. He may, without warrant, arrest anyone for a breach of the peace committed in his view and carry him before a justice of the peace. It doesn't say hold you for 72 hours. It says take your ass right before the justice of peace immediately. Okay? And in cases of felony actually committed or a dangerous wounding whereby felony is likely to ensue, he may, upon probable suspicion, arrest the felon, and for that purpose is authorized, as upon a justice's warrant, to break open doors and even kill the felon, if he cannot otherwise be taken. Forrest Blackstone's Commentary 292. In all other cases, however, the authorities are uniform A constable or policeman has many authorities to make an arrest without a warrant. Authorities cited Shanley versus Wells, 71-3-78-82, 1873. In a case for false imprisonment, the Supreme Court of Maine examined the law regarding arrest and held the principles which the common law regulate the right to arrest or cause an arrest without warrant have been long settled, but both in this country and in England. And these principles, the rights of these parties, must be determined. After citing numerous cases involving the authority to arrest, the court stated, in many of these cases it seems to have been held that the authority of an officer to arrest for a misdemeanor without warrant is limited to breach of the peace or a phrase committed in his presence. Palmer versus Maine, CNT, R period, CO period, 42, Atlanta, 800-803-92, ME, period, 399. This case was upheld in 1899. In a case involving a state liquor prohibition law, a man, while walking down along a public street, was accosted by the police officers and asked if he had any liquor on his person. Okay, again, this begs the question, what's your reasonable articulable suspicion that I have liquor, and what's a reasonable articulable fact? If you don't have that, bug off, Jack. He replied that he did. Thereupon, the officer searched him and found a bottle of liquor in his inside coat pocket. Now, here's the problem. The guy admitted to something that he had no business talking about. He didn't have any. He just said, what's your reasonable articulable suspicion and reasonable articulable fact to believe that I am engaged in the commission of a crime? If you don't have that, fuck off, buddy. I don't answer questions. He was then taken to the police station. The state Supreme Court of Wisconsin said that when the police officer stopped the man, he was illegally arrested and was illegally searched, as he had no warrant to do either. The court said that it is a serious thing to arrest a citizen, and it is more serious thing to search his person, and it must be done in conformity to the laws of the land regarding the law on arrest it held. Now, when they're talking about the laws of the land, we know that if you sold out for privileges and immunities granted to you by the government, that you are presumed and assumed to be a United States citizen and you have no rights. When they're talking about the law of the land, ladies and gentlemen, they're talking about your unalienable fucking rights here, okay? Because you're a state citizen or a state national, okay? You're a member of the Confederate Union of States, and you are protected by the law of the land, and the law of the land is actually attached to the land. It's not statutory. At common law, arrests for misdemeanors were not permissible without a warrant, except for acts committed in the presence of the officer causing a breach of the peace. Allen versus State, 183, Wisconsin, 323, 197, N period, W period, 808, 810, 811, 1924. Thus, in order that the citizen's sacred right of liberty, it's a sacred right. Remember, they pledge their sacred honor to establish the United States of America and form a more perfect union. They professed their sacred honor. This is considered a sacred right of liberty. Remember, men give their lives for you to have this. Be secure and preserved. It has always been fundamental law that arrests without warrant were not deemed lawful, with only a few well-established exceptions of felonies and breaches of the peace. The liberty of citizens would never be safe if such principles would be determined and thus abrogated by statutes. What they're saying here is statutes don't trump the fucking law. Statutes don't trump your rights, but there is a condition here. If you're a United States citizen, if you declare to be a United States citizen, if you're pledging an allegiance to the United States flag, you are subject under civil statutory law, and thus you belong to them. Remember, the only reason they can reach out and touch you where you don't like to be touched is because you granted them the authority by claiming to be something you clearly are not, whether you understood it or didn't understand it when you did it, and is a violation of Title 18, 911, falsely proclaiming to be a United States citizen, okay? Therefore, these principles surrounding arrest are regarded as fundamental law under the American system of government as held the Supreme Court of Michigan. Under our system, we have repeatedly decided, in accordance with the constitutional principles as construed everywhere, that no arrest can be made without warrant except in cases of a felony. What constitutes a felony? Rape, murder, grand theft auto, those are all felonies, right? Okay, so unless you've been accused of that by two or more witnesses and an injured aggrieved party stating the same, then they have no reason to arrest you without warrant. Or in cases of breach of the peace committed in the presence of the arresting officer. In the presence of the arresting officer means that Sally Joe calls because she's all pissed off because you won't come over and tend her flower, and now she's mad at you and would rather see your ass in jail, so she uses the government as a fucking weapon against you, okay? And she says, oh, he's disturbing my peace. Well, if they come and arrest you because Sally said that you were disturbing the peace, but when they show up, you're peaceful and sensible and not loud and obnoxious and unruly, they have no grounds to arrest you. If they arrest you at that point, it's a false imprisonment, it's a false arrest based upon hearsay, okay? This exception in case of breach of the peace has only been allowed by reason of the immediate danger to the safety of the community. So you must be a danger to the safety of community for breach of the peace to be instituted against crimes of violence. Yerkes versus Smith, 157, Michigan 557, 122, in period, W period, 223, 224, 1909, citing Robinson versus Miners, 68, Michigan 549, 557-58, 37, in period, W period, 21, 25, 1888. In Yerkes' case, it was held that the playing of baseball on a Sunday did not necessarily involve the breach of the peace, justifying an arrest. Though it may cause a breach of the peace, the court said that before a summary arrest can be made for breach of the peace, not only must overt acts be committed in the presence of the officer, but they must be violent and dangerous acts of some sort. In the Robinson case, the court held that the liquor law or ordinance, which allowed arrest without process, was unconstitutional because it was not pursuant to the due process of law. Where a man was arrested for public drunkenness, the question arose whether this was an offense for which one could be arrested without a warrant. The Supreme Court of Appeals of Virginia declared the law on arrest. The common law relating to arrest is the law on that subject in Virginia. At the common law, a peace officer may arrest without a warrant for a breach of the peace committed in his presence, but for no other misdemeanors. Gallier versus Commonwealth, 161, VA, 1014, 170, S period, E period, 734, 736, 1933, authority cited. The common law on arrest is the same in every state. As due process of law, the same meaning throughout America. The security of the citizen's liberty in this country is to be more highly regarded than it was in England under the common law. To say it is less regarded is to make a mockery of the revolution. In New Jersey cases, a man was arrested by two city policemen on orders of their superior to do so, alleging that he was guilty of disorderly conduct and was taken to a police station and held overnight. This was done without any charges or complaint made against the man and without any warrant. The only authority for the arrest was that the officers were told to do so. In a suit for false imprisonment, it was held by the Supreme Court of New Jersey that the arrest was without authority and gave the following opinion. The legal principles underlying this case and the one to be applied to the facts is firmly embodied in the roots of the common law, which has been handed down to us from early times unimpaired. In its full vigor for the protection of personal liberty against illegal arrest, the liberty of the person is too important a matter to the state to be interfered with without the safeguards with which the law guards such invasions. This court has said the limits of the power of arrest by a constable without process was well defined at the common law. The regard for liberty of the person was so great that the common law did not confer upon a mere conservator of the peace the power to touch the person of the subject of his own volition, except in those cases when the interest of the public absolutely demanded it. Collins versus Cody, 95, N period, J period, Law 65, 113, Atlanta, 709, 710, 1920. In Pennsylvania case, a woman was arrested for causing and procuring to be made loud and annoying sounds and noises at late hours of the night in a certain tent near a city street. I wonder what she was up to. By beating upon a drum. Upon indictment, her counsel moved that the indictment be quashed as she was arrested without affidavit and warrant while she was in a tent upon private property. It was held that the arrest was unlawful as the act was such that summary arrest was not justified and due process required a warrant for such arrest. It is the undoubted right of every person in this community not to be deprived or depraved of their liberty without due process of law. And if the defendant has been arrested without due process of law, the indictment against her cannot be sustained. It has long been recognized that arrests without a warrant are justified in cases of treason, felony, or breach of the peace, in which actual or threatened violence is an essential element. 1 Hales PC 589, 2 Hawkins PC Chapter 13, Section 8, 1 Burns J. Period 287, 4th Blackstone's Commentary 292, 9 Bacon Abrid 468, 1st Chitty Criminal Law 15, Clark's Criminal Procedures 39, Russell's Crime Volume 3, page 83, 4th American and English Encyclopedia of Law 902, Commonwealth versus Quebec 8 Penn District Rep 521, 522, 1899. It must be remembered that not every misdemeanor involves a breach of the peace. Commonwealth versus Gorman, 192, N period, E period, 618, 620, under the common law acts that were malum per se, that is wrong or unlawfully by their nature, were often felonies or breaches of the peace and subject to arrest without warrant, but that is not the law for an act that was only malum prohibitum, being made unlawful only by statute and without such enactment were otherwise innocent acts. The law asserts that for such statutory misdemeanors not amounting to a breach of the peace, there is no authority in an officer or office to arrest without a warrant. As general principle, no person can be arrested or taken into custody without a warrant, but if a felony or a breach of the peace has in fact been committed by the person arrested, the arrest may be justified. Burns versus Urban, 40 New York, 463, 466, 1869. See also Cunningham versus Baker, 104 Alaska, 160, 16 SO period, 6870, 1894. While the search and seizure provisions of the Constitutions regulate the manner in which warrants can be issued, it is the Due Process Clause which protects citizens from unlawful arrest without warrant. No person shall be deprived of life, liberty, or property without due process of law, and under like restrictions in the Constitution, it has been held in some states that arrest shall not be made without warrant except for felonies and for breaches of the peace committed in the presence of the officer arresting. North versus People, 139, 3, 81, 28, M period, E period, 966, 972, 1891 is the case. Thus, where an arrest is made without warrant in a case not involving a felony or a breach of the peace, the arrest is unlawful. Arrest without warrant, where a warrant is required, is not due process of law, and arbitrary or despotic power no man possesses under our system of government. Thus, when a police officer exceeds his powers in making an arrest, he becomes a trespasser, and he is liable for false imprisonment. Musco versus Commonwealth, 86 Virginia, 443, 10 S period, E period, 534, 536. For other authorities on this matter, see one, I'm not going to read all those citations. Holy fuck, there's a lot of them. Treatise on Law of Sheriffs, Volume 1, Section 166 in 1941. So let's get to the conclusion. Conclusion. It is a maximum of law that liberty is more favored than all things. DIG Digest 50, 17, 122. Thus, the law favors liberty above all things and applies the most liberal interpretation to it. The common law rule regarding the procedure and process for arrest was established in this country in Allor versus Wayne Cove, 43 Michigan, 7697, 4 N period, W period, 492, 495-96, 1880. Mr. Justice Campbell says, the Constitution has also provided that no one shall be deprived life, liberty, without due or property without due process of law, and has provided that no warrant shall issue except upon oath or affirmation establishing probable cause. It has been settled for centuries, and the doctrine has been recognized here that except in cases of reasonable belief of treason or felony or a breach of the peace committed in the presence of the officer, there is no due process of law without a warrant issued by a court or a magistrate upon the proper showing or finding. It is, thus, fundamental that due process of law clause of the Constitution protect the citizens from unlawful arrest. State versus Quinn, 97 S period E period 62 64 S period C period 1918 was the year of the case by the common law, which is that law due process guarantees. A citizen cannot be summarily arrested when he is found violating a law that is only a misdemeanor. A warrant must first be acquired to arrest such person pursuant to due process of law. If that which constitutes due process of law is made to depend upon the will of the legislator as expressed in a statute or character, then no fundamental principle of law or rights are perpetrated or secured against abrogation. An arrest is a deprivation of one's liberty. The state constitution requires that no person shall be deprived of life, liberty, or property without due process of law. Minnesota Constitution, Article 1, Section 7, again, it's found in all 50 state constitutions. The procedure for arrest under the common law is what constitutes due process today, as the Minnesota Supreme Court held. What is due process of law is usually a traditional and historical question. Was it due process of law under the common law, and did it remain such up to the time of adopting the Constitution? C period M period Nelson Lumber Co. versus M. Keenan, 61 Minnesota 219-222. The law is very jealous of liberty of the citizens. Where the offense is less serious, the greater the formality prescribed for the exercise of the power which can deprive the citizen of his liberty. Porter versus State, 124, Georgia, 297, 52, S period, E period, 283, 285, 1905. The citizen cannot be summarily deprived of his liberty because of his infraction of some ordinance or statute, unless at the common law he was liable to arrest. The misdemeanor traffic statutes involved in this case is such that it does not allow the defendant to arrest the plaintiff without the formality of a warrant. Therefore, the defendant is guilty of false imprisonment for arresting the plaintiff without authority of law. The foregoing proves that the common law surrounding arrest was always recognized in this country and is thus a requirement for due process in depriving the plaintiff of his liberty. It is the law of the land. As such, these principles are constitutional mandates and cannot be abrogated by mere statutes. Respectfully submitted by the state jurist E.T. de jure by Charles A. Wiseman. So as you see there, it was found that the officer arbitrarily, with neglect, negated the man's rights under the presumption and assumption that the Department of Motor Vehicle Codes somehow granted this man authority to be arrested because he would not give him a driver's license. And he ended up paying the man 10 fucking G's out of his own pocket for violating his rights. This case was had in like 1993. And so for people telling me that, oh, well, cases prior to 1933, they're not accepted in the court. I'm here to tell you right now, change the jurisdiction. Don't fall into the civil statutory whims of the legislator and Congress assembled, okay, as a United States citizen, but rather come in as a state national with an allegiance to the people of the state to secure our sacred liberty, all right? And that's the way you move. When we come back, we'll be talking about breaches of the peace and felony arrest. This all goes into status correction and then how you enforce it once you correct your status. Understand that you have to assert yourself. If you don't assert yourself and tell them who you are, they will tell you who you are. And if you don't have a set of laws that you abide by and that you follow, they will provide laws for you, okay? The very reason for government being instituted originally was to protect our rights. As it rolled over into this commercial monstrosity we have now, they're basically saying that everybody is a heathen, nobody knows the law, we're just going to make them subject to us, and we're going to exercise our authority to create statutes at a whim, which is taxation without representation, and we're going to hold them liable for it, okay? Under the pretense that we presume and assume they're U.S. citizens and they're subjects of ours. Which begs the question, where did they get the warrant of attorney to operate outside of Washington, D.C.? Because I sure the fuck am not one of their subject serve fucking pauper slaves, right? So you got to let them know, hey, I'm not a pauper serve fucking subject slave to you jackass motherfuckers out of Washington, D.C., arbitrarily acting as though you fill some fucking office, okay? Where's your oath of office? Where's your delegation of authority to operate outside of Washington, D.C.? Under Title 26, 2032, AE 11, you're supposed to be independently bonded with the Treasury because you're operating under a DUNS number, all right? You're operating in commerce, motherfucker. Where is your criminal policy? Where's your bond attached to your oath of office? Which your bond should have been in play long before you took the oath of office. Where is that? You're going to have to put that on the record. We challenging jurisdiction around this bitch. We ain't playing. I'm here by special divine appearance to let you know who the fuck I am, and what you stepped on is a landmine of knowledge. A man who is not going to let people from the past, including the forefathers, die in vain when they said that they pledged their sacred honor for our liberty and our posterity and our fucking freedom. So once you learn how to assert yourself in that manner, you will see that things quickly change in your favor. All right? Because they don't want to go to Guantanamo Bay. And I, myself, want to see a lot of these shit stains go to Guantanamo Bay. I want to see it. I want to put a few of them there. I'm excited about having this knowledge to be able to do that shit. So, with that said, I love you guys. When we come back, we'll be talking about breach of the peace and felony arrest.